Hello and welcome to Law Logical, your weekly dose of the basics of law. Every week, we bring you insightful discussions on the laws of the land to help you stay informed. Today, we will discuss sections 296 and 294 of the Bhartiya Nyay Sanhita, a significant provision that deals with public mischief and obscenity in public. So, if you want to know what it covers, the punishments prescribed, and some real-world applications, stay tuned till the end. To begin with, Section 296 of the Bhartiya Nyay Sanhita, BNS, deals with public mischief, which refers to acts that cause disruption to public peace and order. Public mischief is considered a serious offense because it can create panic, harm public safety, and disturb the normal functioning of society. Simply put, if a person willfully spreads false information that is likely to incite fear, alarm, or public disorder, they can be punished under this section. The key elements of this section are deliberate act. The person must knowingly spread false information, intent to incite public disorder. The act must be likely to create fear or disturb public peace. Possible consequences. If the false information leads to violence, mass panic, or any harm to the public, it strengthens the offense. Now, let's talk about the penalties under Section 296. As per the Bhartiya Nyay Sanhita, a person convicted under this section may face imprisonment for up to 3 years, or a fine, or both, depending on the severity of the act and its consequences. For example, if someone falsely spreads a rumor about a bomb in a crowded public place, it could lead to mass panic, stampedes, or even casualties. In such cases, the accused may face stringent punishment. Apart from public mischief, Indian law also penalizes obscene acts under Section 294 of the Indian Penal Code, now covered under the Bhartiya Nyay Sanhita. This section states that anyone who commits an obscene act in a public place or sings, recites, or utters obscene words in public, causing annoyance, can be punished with imprisonment for up to 3 months, a fine, or both. Some notable cases include Milind Soman's controversial nude run, 2020. The actor was booked under Section 294 IPC for posting an obscene photograph while running nude on a beach in Goa. Poonam Pandey case, 2020. The actress was arrested in Goa for shooting an alleged obscene video in a public place. Mumbai Railway Station Obscene Act case, 2021. A couple was arrested for engaging in an obscene act at a railway station, highlighting how public decency laws are enforced. Court courts in India have ruled on several occasions that obscenity must be determined in the context of contemporary moral standards. For instance, in Avik Sarkar vs. State of West Bengal, 2014, the Supreme Court held that obscenity should be assessed on whether it appeals to prurient interests or has artistic and social value. In Bobby Art International v. Om Pal Singh Hoon, 1996, the Supreme Court upheld the artistic expression in the film Bandit Queen despite its explicit content, emphasizing the need for contextual understanding. These cases demonstrate how courts strike a balance between public decency and freedom of expression. To understand this law better, let's look at some real-life instances. Fake news and public panic. In the past, there have been cases where false messages about communal violence or natural disasters were circulated on social media, leading to riots or mass evacuations. If such acts are done knowingly, they can attract punishment under Section 296. Hoax bomb threats. We have seen cases where people call in fake bomb threats at airports or schools, causing chaos and emergency evacuations. Such actions not only waste public resources, but also create unnecessary panic. Courts have taken a strict view of such offenses, ensuring that culprits face legal consequences. Medical and pandemic-related misinformation. During the COVID-19 pandemic, false information regarding cures, vaccines, and restrictions led to public confusion and panic. Under Section 296, spreading such misinformation with malicious intent could lead to legal action. Now you may wonder, how is public mischief different from defamation or sedition? Defamation, under Section 354 BNS, relates to harming an individual's reputation, while public mischief affects society at large. Sedition, under Section 150 BNS, involves acts against the government's authority, whereas public mischief concerns spreading panic or disorder in the general public. Thus, Section 296 is specifically meant to tackle false information or rumors that disturb public peace. A common question is, are there any defenses against charges under Section 296? Yes. If a person can prove that they had no intent to cause public alarm, the information they spread was believed to be true at the time, or there was no actual public disturbance caused, then they may not be held liable under this section. However, it is always advisable to verify information before sharing it, especially on social media. So, to sum up, Section 296 of the Bhartiya Nyay Sanhita is a crucial provision to prevent false information from causing public disorder. With the rise of digital communication and social media, it is more relevant than ever to curb misinformation and ensure public safety. Similarly, laws against obscene acts in public places, such as those covered under Section 294 BNS, play a vital role in maintaining public morality. These laws have been enforced in several high-profile cases, and courts have provided clarity on what constitutes obscenity. What do you think about these laws? Do you believe stricter regulations are needed to tackle fake news and public mischief? Let us know in the comments. If you found this video informative, don't forget to like, share, and subscribe to Law Logical for your weekly dose of legal insights. See you in the next video. Until then, stay aware and stay legally informed.